Hi everyone, this is Dr. Victoria Nale, and here with me is my new colleague, Toche from the Energy Dispute Center. And in today's webinar, we want to focus on a discussion on the effectiveness of the Energy Charter Treaty, because I'm sure most of you are well aware of the treaty, the various instances where the treaty has been used to solve energy disputes, and also instances where questions have been raised, like how effective is the treaty, the Energy Charter Treaty, in this energy transition era, considering the fact that given the 2015 Paris Agreement, every country is concerned about transitioning to a low carbon economy. So some people, some scholars have attacked the Energy Charter Treaty that it's not modernized enough to tackle the energy disputes or even to respond to this era of energy transition and climate change. So in today's webinar, Ms. Tuche Eguden, I hope I'm pronouncing your name well, will be discussing the issue of the Energy Charter Treaty and how effective it is. And I also note that she's from the Energy Dispute Center. So this is also a very good organization that is involved in energy disputes. But before we start, I would like Ms. Tuche to briefly introduce herself, give us a brief background about her professional life, where she works, and then afterwards we shall go ahead with a discussion on the effectiveness of the Energy Charter Treaty. Tuche, the floor is yours. Would you like to introduce yourself?
Thank you so much. Again, I would like to thank you for your kind invitation for this webinar. And if I would like to mention about myself, I studied law in Turkey, in Istanbul, and afterwards I moved to London to study energy law postgraduate program. And I received 2 awards from City University of London. One of them was Low Carbon Energy Award, and the other was Energy Sustainability and Security Award. And then I had the chance to start working with Energy Disputes Arbitration Center as one of the Vice Secretary Generals. And currently, I'm also head of Europe, which means that I'm representing the Europe area. So my thesis was actually on Energy Charter Treaty. That's why actually it's one of my biggest questions in my mind, whether it's effective or not, or whether its effects on climate change affect our life or not. So I actually prepared a presentation, so I can share my screen now so that we can start our argument if you want.
All right, yeah, please go ahead.
Perfect. So the question today is environmental protection under the Energy Charter Treaty, whether it's really effective, whether it protects the environment, or is it actually creating a sword? So I would like to start with a case which is between a British company and Italy. I think this just shows the biggest issue in especially energy law. The thing is that the British company is an energy company, private energy company, and also foreign energy company in Italy who is investing. And after they invest, Italy decided to change its regulation. And they say, okay, from now on, we are banning all new oil and gas operations near to the country's coast, which is actually an acceptable regulation, because when you just think about its environmental side effects, it's reasonable. It's a reasonable measure for sure. But when they just regulate this regulation under Italy law, the thing that they faced was lots of cases, especially the copper, which claimed 2,025 million euros since they changed their regulations and tried to protect the environment. So at that point, the question becomes, what can reasonably be expected from the Energy Charter Treaty? And before mentioning the answer of this question, I would like to just state something else, that an annual global energy report by BP states that global carbon emission increased by 2% in 2018, which is a high rate. So at that point, we need to see whether energy sector has an essential detrimental effect on it. Yes, it is. It's actually one of the biggest polluter sectors. But what are they doing? The question is why there is a bad side effect of energy sector, especially to the environment. On that point, before going to energy charter treaty, everyone actually has that question in their mind, which is stating that why we are not focusing on the climate change agreements, why we are just searching for the answer in the energy charter treaty. Can't we solve this issue with the climate change agreements? The answer is so clear. The answer is there is no regulation under the climate change agreement specifically mentioning energy sector. So how can we wait for their solution if they are not even mentioning about energy sector? So even if we state that they are mentioning, so just imagine the Paris Agreement or UNFCCC or Kyoto Protocol is saying that, okay, from now on, the people on the energy sector should impose these rules, but there is no. But even we accept this, afterwards, we will just need to check whether these climate change agreements are effective or not. First of all, what is an effective climate change agreement? How can we say that they are effective or not? There's a threefold threshold, which means that there's 3 steps that they need to meet. First of all, there need to be a broad participation, which means that it's an international issue. Environmental protection should be managed by all the countries, not only 1 or 2. So there should be a broad participation. Secondly, there should be high ambitions. What I mean by saying high ambitions is that they should be realistic, but at the same time, some kind of high targets. They need to reach it. But the important part is that they need to put their own targets on the climate change issues, especially the energy sector, for the energy sector. Lastly, there should be a high compliance rates, which means that there should be a mechanism that just see whether they are relying on the rules or not, because there can be some breaches. So is there any sanction for it afterwards? So let's come to the energy charter treaty, because as we can see, there is no specific explicit regulation under the climate change agreements regarding the energy law. So we can focus on energy charter treaty. Why? Because as I said in the previous slide, there's threefold threshold. And starting from the broad participation, energy charter treaty passes the test because, first of all, it is the only multilateral energy treaty, which means that there are other treaties, but they have just two parties or 3 parties, not like energy charter treaty, which has 54 parties. So it actually has a good rate of just participation. But at that part, we are supposed to check Article 19, which is the environmental protection clause under the Energy Charter Treaty. So when I saw this article, actually, I don't even read the whole article. What I can see is the words shall, should, which actually shows me that it actually gives people some kind of area that they are not actually meant to do it. They are supposed to do their best, but there's no any sanctions, So at the same time, I'm just seeing where it is located. It's Article 19. Like, if you know Energy Charter Treaty, the most important clauses are listed under Article 10 and 13, such as expropriation clause, such as investment protection clause. So when you see the environmental protection clause under the Article 19, the question comes to my mind is why it is just drafted so not with the essential articles rather than that, like in the other articles. So the question at that part should be also, there is another mechanism mentioned in the treaty for the energy disputes and environmental disputes under the Energy Charter Treaty. Actually, that actually creates another question, because all the disputes regarding the Energy Charter Treaty has another article, but when it comes to the environmental protection clause, it has a different, separate clause. So let's see what is it and what it's saying. It says, the Charter Conference will manage the disputes, but it also says it's just going to aim at a solution. So what is the Charter Conference able to do or unable to do? It's not clear. So as you can see, there's just so broad regulated article, so we can't be sure what actually they want from this article. At the same time, like even we say that these articles was drafted in a good way, like if the Article 19 was using a good words, and also if it was located with the other important provisions, there is a fact called regulatory chill. Before mentioning and explaining what it is, I actually want to give an example. In 1992, by the way, it's not an energy case, it's a mining case, but it's so related with our topic. That's why I actually wanted to mention about it. The Indonesian government enacted a regulation, and it says that I'm going to prohibit open pit mining in the protected forests. I guess it's an acceptable regulation because they are just trying to protect their environment. But then some of the mining companies started to sue them. Actually, they didn't even start. They started to threaten them by suing them. And afterwards, Indian government scared and not regulated this regulation, this legislation. And also another case in 2015 is actually a case. So it's between Canadian gold mining company and El Salvador. And as you can see, the claiming amount is $250 million, which is so high. So when you see these numbers, you will just understand that this can create pressure, especially on the developing countries, because as a developing country, I don't have that much budget. So if a private company sues me and claims that much money from me, I would probably not regulate for environmental protection. Rather than I will probably be silent and not regulate. So we need to see what arrangements under the ECT actually creates this problem, especially all of them, but specifically investment protection clauses. I mean, Article 10 and 13. Because first of all, Article 10, for example, gives the foreign investor the right to have a fair and equitable treatment. But the treaty itself doesn't explain what is fair and equitable treatment means. What does it covers? So it creates just lots of questions because of its language, how it's worded. It's worded unclearly. That's why people are just going to these clauses and suing the states to not to regulate, to protect their environment. Also, another thing is that for these protections, like fair and equitable treatment, for expropriation claims, the companies are able to go to the ECT Article 26, which actually gives them the right to sue the state under the international arbitration tribunals. This is also an issue. First of all, let's see the article. As you can see, it gives three options. They can also go to the local courts, but mostly if you are a foreign investor, you don't want to go to a local court, because can you imagine seeing a state under their state courts? You can't just wait that they are going to be impartial. So there can be a problem about it. So they are generally choosing to go to international arbitration tribunal. But at that time, we are facing with some problems, such as, first of all, in the international arbitration tribunal, there is no right to appeal. And secondly, this article is giving the rights to investors to sue the state. So it's actually one-sided. The governments can't sue the companies. Only the companies can sue the government. And there is no specific counterclaim provision under the ECT. So you can't know whether your counterclaim will be accepted or not. This is another problem. So we need to find a balance between the energy investments, like the protection of the foreign investment and the protection of environment. But how are we going to do? Actually, there are two things that we should check. First of all, the conduct of arbitration proceedings, which I mentioned before. I mean, the counterclaim part. And secondly, the assessment of the merits of investment claims. So the conduct of arbitration proceedings, as I said, there are some counterclaims. So under the ECT, there is no specific regulation. It's not saying who can just claim a counterclaim or not. So it's not clear at all. So maybe it should be drafted under the ECT. It should be said this person can sue, can put counterclaim like states. However, in order for counterclaims to function in this way, I mean, if states want to use counterclaims as a sword to the investors, then the thing is that firstly, they are supposed to be accepted by the jurisdiction and admissibility over a state counterclaim. However, as I said, ECT is silent, so there it should be changed. And when it comes to the assessment of merits of the merits of investment claims, there is a fact that there are huge numbers of cases going on in all around the world regarding the environmental protection under the ECT. And you can see the number here. It's $2.80 billion. It's huge. So there is a big situation going on right there. So when all the things are just coming into the mind, and while you are discussing it, the question comes to mind, like, isn't there any exception clauses? Like, why are you just saying this, or is someone else thinking about it? Yes, there's an exception clause under the ECT. However, the thing is this provision doesn't cover investment protection provisions. In other words, normally, yes, environmental protection is an exception clause, but when it comes to the investors, foreign investors, they can't use this. The state can't use this as an exception clause because the ECT says like that. For example, let's see Article 13 of the ECT, which is actually regulating the expropriation clause under the ECT. And it says that you can't expropriate, you can't do any expropriation, especially direct and indirect expropriation, but still it's not giving any clear definition what is expropriation is. So there should be a clear definition of expropriation. So there's a case between TechMet and Mexico. TechMet is a foreign investor in Mexico, and Mexico was dealing with the issues that we were talking about. It was just trying to protect its environment. But in order to do that, it was supposed to expropriate. And guess what? TechMet sued Mexico in front of its tribunals. And again, there was a huge compensation. So it was just a problem. And the thing is that the thing that we shouldn't forget is that even though you withdraw Energy Charter Treaty, the investors can sue you 20 more years. So even today, for example, Mexico withdraws Energy Charter Treaty, and tomorrow it just puts a new regulation regarding environmental protection and expropriates a foreign investor, then again, those foreign investors can sue them for 20 more years. So there is no getaway. They are just stuck in the treaty, especially in the environmental protection area. So how can we solve this issue? Actually, there is two options. First of all, arbitral tribunals can solve this issue by adopting a specific way, but it's not all right, because in international arbitration, in the fundamental principles of international arbitration, which includes flexibility, the broad discretion of an arbitral forum, and the competence rule, it's not allowed to just adopt only one interpretation way. So it's not allowed. So what can we do? What we can do is reforming the ECT. But how are we going to do? First of all, we are going to create some exception clauses. So we are going to carve out the treaty obligations. What I mean is, for example, I was stating there's a problem, especially in the expropriation area. Lots of states just decided to expropriate foreign investors' investment. By the way, it's not also fair for the investor too. But when you look both sides, the state is just using its sovereignty right because it's just regulating its environmental regulation, but still it can't, and it's becoming just regulatory chill. So why don't we creating some new obligations under the treaty, some exceptions? We can draft a new expropriation clause, for example, under the Article 13. So actually, there is a treaty like that. It's 2020 US Model BIT. It's actually creating an exception for the expropriation clause and saying that if there's public health, safety, or environmental issues going on, then there is an exception clause. But for me, I'm not saying this article enough. So I decided to draft my own article. So I'm suggesting that this can be, for example, an exception clause for the Energy Charter Treaty. Let's see my clause. Here is it. It is. First of all, why I believe that this is a better, because again, there are some unclarities in it, because again, no one is saying that what is indirect expropriation. Okay, you can find the answer from the cases, like you can see the other cases decisions and you can try to find out, but still I'm saying that there's not only one interpretation, right? All the tribunals has on their interpretation method, so we can't be just sure. So let's draft all of them together. So that's why I drafted and clause like that, and I put some thresholds and test on it. As you can see, I say like there should be proportionality, but what also I say what is proportionality means. So I'm just giving some more threshold, some more tests, so the governments will pass all of them, and afterwards we are going to say that, okay, this expropriation is legal, which means that you don't need to pay any compensation. Thank you. My presentation is today like that. Let me stop sharing my screen. Yeah.
All right. Thank you very much for the brilliant presentation. It's really timely because we are seeing a number of cases, lots of cases with respect to energy arbitration, and also there are many cases that have come under the Energy Charter Treaty. I note that I worked at the Energy Charter Secretariat in Belgium. I worked there in 2015, and that was a time where they are moving towards modernization of the Energy Charter Treaty by adopting the International Energy Charter of 2015. Because initially this was a European initiative, but now they're trying to expand to other countries. So in that respect, I would like to ask my first question, but I also invite our participants. I've promoted all of them to be panelists so that they can share their videos. So if you have a question, please do raise your hand so that you can get a chance to ask your question. But prior to that, I'd like to ask the question, with this modernization, the adoption of the 2015 Energy Charter Treaty, do you think it's effective to apply to other countries in Asia, in Africa, and also like Arab countries with respect to dispute resolution, but also the acceptance of the people for this treaty? So in your opinion, since you are into energy disputes, what is your say with respect to acceptance of the modernization of the International Energy Charter Treaty to be accepted by all people, not only Europeans, but also all other countries that are involved in energy and mining?
So actually, the biggest issue I'm seeing in this area is that Energy Charter Treaty is actually something really essential for the developing countries and undeveloped countries, because it's actually something that invites the foreign investors, and that you are just earning their trust, because if there's an Energy Charter Treaty which actually gives them the right to just be there, and so that they will just trust the government and make their investment on those areas. So when it comes to Africa and Asia and Middle East, like especially for example, I'm living in Turkey and we are a developing country. So for now, what we are trying to do is just find some investors, foreign investors. That's what we need for our economy. So I think the key in that renewal, let's say redraft of Energy Charter Treaty, is to find balance. So you need to just not to look from one perspective. You need to just compare them. If you are just giving extra rights to the states, you need to also secure the investors. So while drafting this agreement, if the redrafters just follow a path that they can also rebalance the ambition of two parties, I believe that it can work. But the biggest problem is that, for example, Italy is going to withdraw. Actually, it withdrew. And I believe that Italy was an essential party because it's one of the developed countries. And when you see that Italy withdrew it, it's just frustrating. It's just going to continue like that. So it should be redrafted. And also, I knew that, and I just have Charter Secretariat is discussing to renew it, but they just can't decide how they should do it.
All right, thank you very much. I see, do you have a question from the participants? Please feel free to ask your question.
At the same time, as you are also my new colleague now under the Energy Charter Disputes, Energy Disputes Arbitration Center, what we are trying to do with EDAC is that we are creating a new tribunal with the experts of energy and also with the experts of environmental law, so that we believe that we can create a safe area, and we will see whether it will change lots of things, but we are now started to be added to the contracts. I guess this is a good thing. I hope the countries, especially the parties of the ECT, will decide to put us in their contracts. So maybe it will be a good option for us to prove ourselves. At the same time, I believe that we might solve this issue by our arbitrators.
All right. Actually, I wanted to ask the second question that is connected to EDAC, the Energy Dispute Center, because we see the Energy Charter Treaty has enjoyed lots of privilege with respect to tackling energy disputes, and we hadn't seen any other specialized institution that is focused on energy apart from now that has come up. So let me try to. So in that respect, how complementary is the Energy Dispute Arbitration Center with respect to resolving energy disputes and also not only resolving energy disputes, but also including various arbitrators from the various countries, various regions, because initially arbitration has been seen as being first male-centered and then European-centered. And there have been initiatives in different countries in Latin America and in Africa where arbitration centers have been set up, but no center had really focused on the energy sector. And I think the establishment of EDAC has come at a point where we need more expertise, but we also need more representation in arbitration with respect to the energy sector. So how complementary or what value does the center add with respect to resolving energy disputes in line with the Energy Charter Treaty?
Yeah, actually it was an amazing question. The thing what EDAC is trying to build is that, first of all, it is the first sectorial-based arbitration center. So which means that we are focusing on energy, even though we are solving other kinds of disputes. So we are not limited only to energy. We cover all the areas, but this is our expertise. So what we are trying to do with EDAC is that we are trying to find all the arbitrators who are the best in their branch. If they are the experts of energy, we're inviting everyone, such as you, because we know the key people in this area. So we are trying to just reach them and just build a platform that all the energy experts will be. So within EDAC, I think the sectoral-based arbitration center was a necessity because, for example, I made a research on it and I saw that nearly 51% of exit cases are belong to energy sector. This rate is so high. This shows us actually a necessity to just develop a sectoral based arbitration center. And by adopting this new perspective, like only focusing on energy law or saying that we are experts of energy law, I think this is necessary in all areas. So I believe that there is actually a competition between the arbitration centers, but that it shouldn't be like that. We should work together, and each arbitration center has their own professionality and expertise. But with EDAC, we believe that we can solve the energy disputes transparently. Uh, so I believe that it was a necessity. And as I said, we are finding and reaching out all the essential people in the energy area. So that's actually the biggest importance of EDAC. And also, we have a background in this area. So we have been doing some trainings for the energy lawyers. So we have already know everything about energy law, and we have the arbitrators, professionals, academicians, companies in it.
All right. Thank you very much for that. Do you have any questions from the participants? If not, then we shall have the concluding remarks, because we know that the Energy Charter Treaty, it brings together companies, but also the states. So in the concluding remarks, I would like you to give your views or your opinion on how we can ensure that many people, many states actually sign the Energy Charter Treaty. Because I think at the moment there are less than 60 member countries who have signed the treaty, and there are observers who have signed the International Energy Charter. But for countries to be party to the treaty, they have to actually agree to the rules. And for some countries, the parliament has to pass laws that accept or accede to the Energy Charter Treaty. So what is your opinion, or what is your advice for the policymakers? Because it's basically the policymakers in governments who decide whether their countries should be party to this treaty or not. So what are your concluding remarks in that respect to the policymakers, but also for the companies to have confidence in the treaty itself? So this will just be the concluding remarks, and then it will be the end of our webinar, since I don't see any other questions from the participants.
Thank you so much. I believe that the policymakers just needs to focus on, like, they are right, they have the sovereignty, so they are supposed to regulate whatever they want. So if they want to protect their environment, they should. But there should be a change under the Energy Charter Treaty. So if this treaty wants to work, and if they don't want to lose lots of countries such as Italy, France, so they need to make a change in their own articles. By doing this change, by redrafting the agreement, I believe that all the policymakers, like all the countries, will at least regulate their own environmental protection clauses without any hesitation. I think this is the most essential part, because they want to take the measures to protect the environment. Otherwise, it's going to turn to a chicken and egg or egg dilemma. They can't regulate, and climate change is happening, so they can't even take any action because the investors will sue them. So I guess at that point, the states just should understand that we need to protect the environment. Okay, we need investors, but also we need to protect the environment. So there should be someone should find the balance. And after building this balance, I believe that all the issues will be solved under the ECT. And by solving climate change under the Energy Charter Treaty, I believe that all the sectors just follow the path. So let's make energy sector the leader of this lead.
All right, thank you very much for that. We've reached our time limit. This ends the end of our webinar. I encourage you to share the link, the YouTube link which I've shared in the chats, with all your contacts who have missed the webinar. And I also note that we are live on YouTube. So for the people who haven't been able to join us today, they'll be able to watch the video afterwards, because they will get a notification that the new video is out. So thank you very much. It was really a pleasure hosting you. And I'm looking forward to working with you at EDAC And our participants, thank you very much for taking time to join us for this very interesting and timely webinar with respect to energy disputes, but also the effectiveness of the Energy Charter Treaty. So this marks the end of our webinar, unless if you have any other concluding remarks, if you want to share your contact details, that's okay. I can give you a chance to do that.
Thank you so much. Thank you. It was a pleasure to have a webinar with you today. Thank you so much.
All right, thank you. This marks the end of our webinar. Bye-bye, and stay tuned. And don't forget to subscribe to my YouTube channel, Dr. Victoria Nalole. It has experts from different countries discussing different topics on energy and mining. Stay tuned and bye-bye.